Hearing will start now.
Good boy. Sorry, ma'am.
This is originating application 192 of 2023, Babel Holding Limited. Originating application 193 of 2023, Babel Asia Asset Management Private Limited. Originating application 194 of 2023, Babel Block Limited. Originating application 195 of 2023, Moon Alpha Financial Service Limited. And originating application 196 of 2023, Sheena Trading Services Private Limited.
All right, good afternoon, Mr. Alexander Yo, Mr. Ang An Liang, Ms. Yeo Zening, together with your trainee, Mr. Richard Xu, for the applicants, correct?
Yes, correct, Your Honor.
Right.
We also have instructing solicitors from Kirkland and Ellis, which we had written in for permission for them to attend.
Yes, okay.
One additional attendee from Kirkland and Ellis will be Mr. Neil McDonald. May I humbly ask for permission for him to attend as well?
Yes, okay, thank you. All right.
Much obliged, Your Honor.
The contesting non-parties, derived, Mr. Abraham Burgess, Senior Counsel.
Your Honor, Daniel Hong from Providence Law Asia here. I have my colleagues, Mr. Burgess, in the waiting room. He's not been put as a panelist and he's unable to speak.
All
and
right,
I said the same.
hold on a moment. Annie, can we bring Mr. Burgess in, please?
Yes, please give me a minute. Thank you.
All right. And with Mr. Nawaz Kamil, Mr. Elston Yong, and of course, Mr. Daniel Huang, you have a trainee. Was it Mr. Liu Enning, was it? Or Mr.
Yes, that's correct, Your Honor.
All right.
And I also have with me in attendance my instructing counsel from Ashes ADT, Mr. Rob Chow and Mr. Karan Puri, as well as Derived coordinating solicitors from Hong Kong, Ashes Hong Kong, which represented by Mr. James Comber.
That's all right. Thank you.
Much obliged, Your Honor.
All right. Thank you. For Genesis Global, Mr. Daniel Cha from Pro Legis and Mr. Jonathan Tang and Michelle Lee from Morgan Lewis.
That is so, Your Honor. Thank you.
All right. OUE Commercial, Mr. Ng Wei Xiang.
Your Honor. Yes, Your Honor.
Paris State, Mr. Chu Hua Yi and Mr. Mark Tan.
Yes, Mr. Court, Your Honor.
Right, thank you. Mr. Wang Li, Ms. Carol Yen from Remy Chu Chambers.
Yes, Your Honor.
All right, thank you. All right, well, Mr. Burgess says, all right, thank you. All right, this afternoon I will to give my decision in the matter. Mr. Chia, though, I understand you wanted to address me.
Yes, Your Honor. I just wanted to.
Hold on. So it's a bit irregular because I am giving my decision this afternoon.
Yes, Your Honor.
Yeah, I don't like surprises. I don't like letters coming in at 2 p.m. or whatever it was. If your client has anything to say and they want to make an application, they can make an application today vis-a-vis the sealing application. But unless your clients are arguing that ERDA is unconstitutional or something of that nature, I really don't see why I should give you time to speak when I've already indicated I'm giving my decision this afternoon.
It's not in respect of the sealing application, Your Honor. It's in respect of just the extension of the moratorium. And
yes, I'm giving my decision this afternoon for the extension of the moratorium. So I don't understand why these things happen, Mr. Chia. You know I don't like surprises.
I do.
This afternoon was for my no, stop.
Yes.
This was for a decision.
Yes, Your Honor. If I may just explain this, happy to leave it in Your Honor's hands on this.
No. I don't like it when counsel come up to me and say, "Oh, we're going to make a few minutes submissions. We're going to leave it to the court." I already shut down several of these. I really don't find them helpful at all, and I really don't like this kind of thing, Mr. Chia. And you should know that.
I do. I did, however, at the last hearing say that we just wanted to settle our client's position. And Your Honor does know that the substantive arguments on this actually took up the entirety of the hearing. I had begun, and I actually checked on this to say that we did want to actually just set out our client's position and we're happy to leave it to the court. And that was what I'm trying to do because I just didn't have time.
Really, I already said this was my decision. Do I need to call all of you down physically?
No, Your Honor. No, Your Honor.
No, this is not on, Mr. Chia. And your reference to what happened that day, I already said this is my decision this afternoon.
Yes, Your Honor.
No, what? No, Mr. Chia. You don't do this kind of thing to me. Your primary duty is to the court.
I hear you.
I've already said that my decision is to be conveyed this afternoon. So why do I get letters like this at 2 plus in the afternoon, just before hearing at 3.
Your Honor, I think what has happened, and this is, I'm speaking on behalf of myself, is that when I had checked through the records, I realized that there might have been a situation where Your Honor may not have had the benefit of my information.
So today, this afternoon, I'm not giving my decision, am I? Is that short of it, Mr. Chair? I am you are really constantly pushing me to really come to the point where I'm going to call down everyone and ask everyone, what's the point of my scheduling a decision when counsel come in at the last minute to ask me for arguments or to address me in this way?
I'm not here to set
If
up.
you're not here to argue, why say anything at all, Mr. Chair?
I've just been asked by my clients.
No, it's not enough to say you've been asked by your clients. Mr. Chair, you really don't seem to understand. I don't know whether Zoom is not conveying to you my utmost unhappiness about how things are panning out this afternoon. It was for decision. No. I am not happy, Mr. Chair. I'm not happy with you. I'm not happy with your clients. I'm not sure whether I should be unhappy with Morgan Lewis.
I understand, Your Honor. As I said, I leave it in Your Honor's hands.
No. My primary problem is I do not like counsel coming into me and saying, oh, I just need a few minutes to say something. I leave it to the court. In that case, I really have to ask whether it's something that you have to say to the court at all.
I hear Your Honor on this. And if Your Honor can just give me 1 minute, and if Your Honor is not...
No, if it's something that's said in 1 minute, does it have to be said at all?
It does.
No, Mr. Chair. So please, in future, convey to your clients.
I will.
I don't like this kind of thing. You either say it, you put in proper submissions, or you don't say anything at all. Is that clear?
I understand, Your Honor. It is clear.
All right. What do you wish to say?
The only thing I wish to say is that our clients are not taking a position in respect of the moratorium. However, they do urge your client, Your Honor, to consider a shorter moratorium because of ongoing discussions that is happening between Moon Alpha and our clients. And our clients, Genesis Global Capital, is the largest creditor. That is all, Your Honor.
All this should have really set up earlier. All right, Mr. Chair, but please bear this in mind in future. All right, I really don't like surprises of this nature when I'm about to give my decision.
I understand, Your Honor, and I apologize on behalf of my clients.
I really don't think this was worth my time. All right. So all others present, please bear that in mind. I really don't like our situations where counsel say they need a few minutes and then they leave it to the court. You either make full submissions or not. I hope everyone else bears that in mind. It is, and especially on a day when I'm supposed to convey my decision. All right, I will now convey my decision. These remarks will be available to parties after this hearing, and I will recounted the various arguments briefly. These are only my brief decisions, which I will add to if needed. Now, the following issues are up for determination: whether the sealing applications should be granted, whether the requirements for the extension of moratorium have been met, which raises a number of sub-issues, primarily whether the statutory requirements under Section 63 and 64 of IRDA have been fulfilled, whether Scotland requirements have been met, and whether substantive consolidation of deed pool structure appropriate mechanisms to be utilized in the scheme of arrangement, and what the scope of the moratorium extension should be. So in relation to the sealing applications, I accept the arguments of the applicants in favor of sealing the documents at this stage. The test is one of balancing the competing interests in play. The applicants argue that the sealing of the documents is required to safeguard the commercially sensitive information relating to the identity of the applicant's creditors in order to prevent these creditors from suffering a potentially negative market reaction to news of the exposure to the Babel Finance Group. On the other hand, the objecting creditor argues that the sealing application should not be granted, as there is a need for the scheme creditors to be able to consult with each other on the appropriate steps regarding the moratorium extension applications and how their interests might best be protected. At this stage, where the court is only concerned with the extension of the moratoria, rather than the approval of the scheme meeting or sanctioning of the scheme under Section 210 of the of the Companies Act, the need for transparency and the ability of the scheme creditors to consult with one another is less pressing. Thus, I am satisfied that at the present stage of the proceedings, the importance of safeguarding the commercially sensitive information in the documents outweighs the interest that would be served by releasing this information to the public. Hence, the sealing applications are allowed. I am satisfied as for whether the requirements for extension of moratorium have been fulfilled. I am satisfied that the moratorium should indeed be extended. The statutory requirements under 63.3 and 64 of IRDA, as well as the Calgon requirements, have been met. And furthermore, the use of substantive consolidation and the depot structure in the proposed scheme is not inappropriate in principle. Now, turning first to section 63.3, after considering the definition of the company and section 246 of IRDA, I go on to note the various factors in section 246.3, which lists several factors which would support the determination that a foreign company has such a substantial connection, including that Singapore is the center of main interest of the company. Now, aside from the Comey analysis, a broad approach to the question of substantial connection may be taken, and generally a company would have to conduct activities of some permanence in Singapore as opposed to merely transient activities, and I refer to my own decision in ZipMax. I'm satisfied that Moon Alpha and the other foreign applicants have a substantial connection with Singapore as they carried on business in Singapore. Each of the foreign applicants has clients and creditors in Singapore, and at least some of the work appears to be conducted by a single team working out of Singapore. I'm satisfied, therefore, the foreign applicants have such a substantial connection and are therefore corporations liable to be wound up under IRDA as required under 63.3. Arguments were made on the applicable lexitis for cryptocurrency. However, the present application is not the appropriate juncture for the court to address this question. Turning then to the Calgon requirements, I'm satisfied that moratorium extension applications are made bona fide and that there is a reasonable prospect of the scheme working and being acceptable to the general run of creditors. Although clear expression of support for the scheme from most creditors is absent, that is not necessary at this stage. The court does not require a poll of the scheme creditors at this stage. Rather, the court considers whether the scheme could be acceptable to the general run of creditors. The court also does not delve into a detailed assessment of the reasonable prospect of the scheme working. Rather, it takes the assessment on a broad basis only. What has been proposed, namely a combination of pooling, conversion of assets, and fresh injection, cannot be said to be so unworkable that it should be rejected out of hand and not left to the creditors to vote on. Thus, given what has been adduced at this time, I'm satisfied that there's a reasonable prospect of the scheme working and being acceptable to the general run of creditors. As for the issue of bona fides, what has been raised goes to legality and sufficiency of disclosure. The objecting creditor argues that lack of bona fides is evidenced by the applicant's failure to disclose their breach of certain statutory licensing requirements under the PSA and SFA. The objecting creditor contends that the business activities conducted by the Babel Finance team in Singapore fall within the definition of digital payment token services and the Part 3 of the first schedule of the PSA, meaning that these activities need to be licensed by the monetary authority, but were not. The objecting creditor further submits that the applicants failed to obtain the requisite capital market services license under the SFA in order to carry out fund management activities. However, the applicants argue that the relevant licensing requirements under the PSA and SFA are not applicable to them as the services are offered to accredited and institutional investors only. Where there's a clear contravention of statutory requirements, the court, even in the absence of any regulatory or enforcement action, should not allow its processes to be invoked. Here, however, the allegations of breach made by the objecting creditor are not clearly established. It suffices for present purposes to note that it is not entirely clear or what is before the court that the applicant's activities have run afoul of the regulations as alleged. Coupled then with the absence of evidence of any action taken by MAS, the conclusion is that illegality or contravention of the regulations is not made out. Turning to substantive consolidation of depot structure, at this time, as the court is not dealing yet with an application for a scheme meeting or sanction for a scheme under Section 210, only a preliminary view can be expressed on the propriety of the various mechanisms to be utilized in the applicant's proposed scheme. It suffices to note that the court does not find either substantive consolidation or the depot structure to be inappropriate in principle. The court does have power in considering a scheme proposal to allow substantive consolidation in the depot structure. The language of Section 210 would seem to be broad enough to encompass such actions, and in particular, the terms compromise and arrangement in Section 210 are not limited in their meaning, and there's no reason to find that these terms cannot encompass mechanisms such as substantive consolidation and the depot structure. The Australian cases cited by the applicants on substantive consolidation do assist in showing that substantive consolidation or pooling may be conducted pursuant to a scheme of arrangement, and as for a depot, such use was accepted in RAE DSG Asia. The commingling of funds may be a possible justification for either substantive consolidation or the use of a deed pool in some situations, such as where it would be impractical to individually identify each company's assets and liabilities. For the reasons above, the extension of the moratorium is granted. However, as Mr. Chow may happily note, a 6-month extension as prayed for leaves the matter out of the monitoring and supervision of the court for too long. A 3-month extension is granted at this time. If the progress and shaping of the likely scheme continues well, the court will be open to further extensions of the moratorium. In conclusion, summarize, the sealing applications are allowed, the moratorium extension applications are granted for a period of about 3 months. I will at this time work out a specific date and the specific orders to be granted by the court. All right. Mr. Yo, if you assist me with the orders to be made, please.
Yes, Your Honor. If Your Honor will refer to originating application 192, I intend to use this as a base for each of 192 to 196.
For
With
the
your
same
first
form,
permission.
correct? Yeah, all right.
Yes,
So
yes, Your Honor.
this is in 192.
Your Honor, essentially, I submit that there has been an order in terms of prayer 1 of OA 192, except that prayer 1 subpara 6 should be deleted. That is the reference to no right of re-entry or forfeiture under any lease.
All right, hold on a moment, please. Hold on a moment.
Sorry, apologies.
So what do you wish to amend?
Your Honor, para 1 subpara Roman numeral 6, no right of re-entry or forfeiture under any lease.
All right, hold on a moment. Let me just change. I think it's better for me to take it in sequence. For one, for a period, let me give you a specific date rather than 3 months. Hold on a moment.
Yes, Your Honor. Thank you.
April. Mr. Cha, 3 months. Any issues with that? Or still too long?
My clients had asked for a shorter time period, but as I said, I hear what Your Honor is saying, and I'm not going to push it further.
Yes, all right. 3 months, I think, is the only practicable time period. I think anything shorter would not make any sense. All right, thank you. All right, 3 months. One.
It was filed on the 6th of March. May I suggest, following the same date rule, 6th of June? Would that make sense, Your Honor?
No, that's quite bad. Oh, no, I'm taking 3 months from today.
Oh, I see. Thank you.
All right.
Understood. 3 months from today would bring us to the 17th of July, Your Honor.
Yes. All right, I'm not sure when I can see you exactly. I'll give you to the 21st of July. For
Understood, Your Honor.
paragraph 1 will be for period until 21st July 2023
Thank you, Your Honor.
or until further order. All right, so it's amended accordingly. So subparagraph 1, 2, 3, 4, 5. Okay, so all the subparagraphs from 1 to 5, order, otherwise order in terms.
Yes, Your Honor.
Para 6
Should be deleted, Your Honor.
deleted. All right. Arabic numeral 2, 3, 4, order in terms. All right. Correct.
Yes, Your Honor.
Similarly, for the other moratorium orders, could you recite the numbers, please? This is
OA 193,
193,
194.
194, 195, and 196.
That's correct, Your Honor.
All right. Then let me turn to the sealing application. What was that number again?
Your Honor, HC summons 681 of 2023.
Summons 28. Sorry.
681. Sorry,
Right.
I misspoke earlier.
All right. So summons 681, order in terms, prayers 1, sorry, the whole of prayer 1. All right. Thank you.
Yes.
All right.
Your Honor, there were two sets of sealing applications because we had filed a further affidavit containing essentially the same thing. Your Honor, maybe I'll give you the summons numbers for the first sealing application. So that's 681 all the way until 685. And they all follow the same form, Your Honor. So it should all be prayer 1.
682, 83, 84, and 85, correct?
Yes, Your Honor.
All right. What was 89?
Sorry?
What was 899?
899 relates to the second set of sealing applications. We filed the second set of sealing applications essentially because further revised top 20 list of creditors was filed by my client.
All right.
And the first set of sealing applications essentially was confined just to one affidavit. We wanted to seal the revised list as well, plus certain further letters of
list
support.
will be in 899 and
899, 900, 902, 903.
in the same form, will they? Hold on.
Same form. Yes, Your Honor.
I don't think this is the most elegant way of doing things, but all right. 899, 900, 901. Mr. Yo?
No 901, Your Honor.
Okay.
It's 899, 900, 902,
902,
903,
903, all right.
and 904.
904, all right. All right, similarly, order in terms of prayer 1, all right.
Yes, Your Honor. Thank you. Your Honor,
I think in future it's best that they be consolidated. Each set should be consolidated within the OA, but never mind, I won't do that here.
understood, Your Honor. Your Honor, I realized that there had been certain objections by a creditor derived to the proceedings herein. I do not intend to seek costs in relation to that, Your Honor.
I don't think I would normally award costs for that.
Yes, understood.
Your Honor,
Yes, Mr. Devargas?
yes, Abraham Burgess here. Your Honor, in respect of the Moon Alpha application,
Yes.
Your Honor will recall one issue that was raised by my learned friend and confirmed by me is the fact that our clients had commenced proceedings in the Dutch courts solely for the purpose of quantifying the debts under Dutch law.
Yes.
This is flowing from Kirkland and Ellis's objection to the debt on the basis that the quantum was disagreed. And so we are asking in respect of prayer 3 in OA 195 that there be a carve out for us to continue with that Dutch suit solely for the purposes of quantifying the debt. This is something that is necessary and would be relevant whichever way the proposals go going forward.
All right. Any issues, Mr. Yo?
Yes, Your Honor. The issue of quantification of the debt is not the only issue at stake in the Dutch courts. Essentially, they are commencing hostile litigation against Moon Alpha in order to get orders. And as I understand it, they intend to proceed for enforcement. So I don't think it's just an issue of quantification of the claim. In any event, even if it was an issue of quantification of the claim, it would involve further costs being incurred by the company in opposing that litigation and potentially launching its own counterclaim. So that will be a complete mess, Your Honor.
All right. All right, hold on a moment. All right, Mr. Burgess, I appreciate that the focus of the hearing was primarily on the broad issue and less so on the question of the nature of the Dutch proceedings. The moratorium being what it is, what I propose is that if your clients wish to have the matter sorted out expressly in this court, that I think it might be best to file a separate carve-out application formally. If your client decides to do whatever else, that's up to them. But if they want an order from this court, then maybe a formal application with a hearing.
Yes, I think Your Honor has in fact provided for that under prayer 4.
Yes. So
I'll be happy to pursue that
All right.
option, Your Honor.
all right. Yeah. So you can consider the scope and really what your client wants to do in this context.
Yes.
All right. All right. Anything else, Mr. Burgess?
Nothing further from me.
Right. All right. So, Mr. Yeo, yeah, there might be another application coming up from Mr. Burgess on that.
Understood, Your Honor.
We'll deal with it.
And of course, parties will try to resolve their
If
differences.
you can, yes, that would be better. All right. All right.
Understood. Thank you, Your Honor, for your time.
Anything else, Mr. Yeo?
Nothing further from me, Your Honor, and thank you.
Chia, anything further?
Nothing further, Your Honor. Thank you very much.
Thank you. Anything further from anyone else?
Nothing further, Your Honor, except to thank you for patiently hearing us out on this application.
Thank you. Mr. Ng, your client is otherwise protected, I assume? Nothing further?
Yes, Your Honor. Grateful, Your Honor.
Who else is there? Mr. Chu, anything further?
Nothing further, Your Honor.
Ms. Yen?
Nothing further, Your Honor.
Have I left anyone else? All right, no, thank you. All right, thank you all. Okay, bear in mind, please, future, I don't like to be surprised when you're giving my decision. All right.
I understand, Your Honor, and I apologize to the court.
No, it's something that crops up, but I would like to emphasize. Thank you. Good to
Definitely.
everyone.
Thank you.
Court is adjourned.
Thank you, Your Honor. Good day.
Thank you, Your Honor.
Sense.
Grateful, Your Honor. Good day.
Thank you, Your Honor.